Hello. In this clip from our Justia webinar, Logic for Lawyers, Crafting Persuasive Legal Arguments, Ryan McCarl gives an overview of legal reasoning while discussing the various facets and scenarios you may face while working on legal arguments. Remember, if you want to see more Justia videos on law practice and legal marketing, be sure to subscribe to our channel.
Thank you, Nina. I'm going to go ahead and start my presentation here. So I appreciate you, Justia, for having me, and I look forward to talking to all of you. I'm glad you were able to join us. So today I'm going to talk about logic for lawyers and crafting persuasive legal arguments. We're going to cover a couple different items. The main problem that triggers the need to discuss legal reasoning, which is the habit lawyers and law students have of often using conclusory reasoning. And we're going to talk about a traditional model of legal syllogisms, and then the role of procedure in making arguments. And then the sort of mantra that I use, conclusions plus reasons, and I'll explain what I mean by that. And then talk about how to design good arguments. So I appreciate we've all heard the introduction, so I'll skip over this part. I'll just note that my book, Elegant Legal Writing, has about 3 chapters in the middle on about the substance of legal argument. So it discusses conclusory reasoning. It discusses how to select and use cases effectively and how to craft compelling fact narratives. But to get the book under the word count, I had to take out two additional chapters about legal reasoning. So it's become the seeds of my next project. And most of what I'm going to discuss today relates to that next project. So it's kind of new material. I've been intensively researching legal reasoning and argumentation for the past year or so, in addition to casually before that point, and starting to gradually synthesize what I'm learning from the many people who have tackled this subject before. And as with Elegant Legal Writing itself, I think 90% of the ground has been covered. There's little new under the sun when it comes to logic and argumentation, which has been discussed since Aristotle, at least. As with writing, which has been discussed since Aristotle, at least. But that said, there's always ways to kind of combine past approaches, teach them in a new way that maybe clarifies principles that escaped us earlier, show them by examples, and kind of add my own spin to it as well. So I'll start by saying that legal reasoning is multifaceted, and it's impossible to cover the vast majority of it, much less in a book, maybe even much less in a 60-minute presentation. But I just want to sort of alert you to what I see as being some of the core skills that good lawyers engage in when they're designing arguments and writing briefs. And I would note that these are not really captured very well by traditional frameworks like IRAC and CREAC, the formulas that people are taught to write with in law school. Often, such as issue, rule, application, and conclusion, or conclusion, rule explanation, application of the rule, and then conclusion. Those I'm not a big fan of those frameworks. And the chapter on that point has gotten some attention in my book. I'm probably not going to go too much into depth into them today. Rather, I'll just kind of move on to discussing alternative paradigms that I think are more helpful. But some of the different skill sets involved are selecting and synthesizing rules, interpreting statutes or contracts, which in a way is a type of identifying the rules that apply to a given situation, making and parrying argument moves, from the simplest ones of challenging an opponent's precedents to attacking the credibility of their evidence, attacking claiming that an issue's already been decided. There are many such moves in the law that I'll allude to a little bit later. And selecting and characterizing material facts, which are facts that kind of intersect with the rule, and that you're trying to apply, and that hopefully are sufficient or not sufficient to establish that the rule applies in a given case. Making and challenging inferences, weaving together rules and facts, mutually characterizing the rule to fit the facts, and characterizing the facts to fit the rule. Obviously, to be persuasive, it needs to be a sort of a weaving that's consistent with the authorities. and that's intellectually honest, and that isn't trying to sort of, tweak or embellish the available facts. But at the same time, this is what lawyers often will be doing, which you don't just take the rule and the facts and juxtapose them side by side. You weave them together to show how these facts fit within certain precedent or don't. Telling coherent stories. So some stories are plausible because they accord with our understanding of how human beings normally behave. Some are not, and so this is when preparing for a jury trial, like I'm doing with my firm, Rushing McCarl LLP. We've got 2 upcoming trials, and a lot of that preparation involves taking the elements that we need to prove on the plaintiff's side in this instance, and mapping that onto a story that is going to resonate with jurors, because based on their kind of common stock store of human experience, it all is going to strike them as plausible. It's going to make sense. It'll be consistent with their notions of how people are. And of course, quite a bit of legal argument involves using legal authority. We don't use logic as much. We don't use sort of purely logical arguments as much. It's not like an op-ed. Pure rhetorical moves that are kind of unrooted from authority are usually not very effective. So a great deal of the nuances of great legal writing is appropriately using the stock of legal rules that's available in precedents, such as cases and statutes, treatises, and then private law, such as contracts. And then finally, integrating appeals to policies and values. These cannot by themselves override binding rules, but oftentimes they can be used to argue that one rule applies and not another, or that a rule applies in a certain way and not a different way. And also, using the rhetorical concept of pathos, making the decision maker feel good about the decision because it accords with a particular policy.
Thanks for watching. We hope you enjoyed this video, and if you did enjoy it, please hit the like button and subscribe to our channel for more videos on law practice and legal marketing. See you in our next clip.